How do we use sworn statements of a witness at the time of trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So let's say this is an accident matter, and now you suffered a significant injury, maybe you slipped and fell, and there were a couple of witnesses. What we will do is we will typically send out an investigator to interview and talk to the various witnesses. And importantly, we want to get them to sign a sworn statement. And what does that mean? It means they're now telling our investigator exactly what it was that they saw, when they saw it, and what they observed. And now we're getting them to sign exactly what information they provided to the investigator, and either they will write out a statement or the investigator will write it out, and now they will sign it. Now, why is that important? It's important because now we've locked that person into their particular testimony. It allows the witness to capture their information about what it was that they observed shortly after this incident happened. So now when your lawsuit comes up for trial, maybe it's 2 years later, maybe it's 3 years later, and now we try and obtain the witness's testimony, we now have to track down that witness and get them to come into court. There's a good chance they may not remember all the details of what happened. So we use witness statements in really two ways. We use it to refresh the witness's memory of what it was that they remembered shortly after the incident occurred. And another way to do it is if the witness testifies about something that they thought they remembered. If they testify inconsistently for whatever reason, they don't remember something, or they're testifying about what they think is the truth, and now we show them, but wait a second, Mr. Jones, 2 years ago, our investigator spoke to you, and this is exactly what you told him, and you signed this confirming that that's exactly what you told him. Is your memory better today, 3 years later, or is it better 2 days after the accident? And now he's going to have to try and come up with some excuse as to why his testimony has changed based upon what it was that he observed only 2 days after the accident. So having a sworn witness statement is crucial for your type of accident when there is a witness available, because it locks that witness into their memory, into their recollection, and now they actually sign it, confirm that this is what they observed, and now we hold on to that until the time of trial. So why do I share this great information with you? I share it with you just to give you one strategy, one idea of what we do as your case progresses to trial, specifically with regard to witness statements and why it's so useful at the time of trial. You know, I realize you're watching this because you likely have questions or concerns about your own particular accident. Well, if your accident happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is what I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.